Everyone, welcome back. I think you can mute yourself. We have the profound honor of ending our first day with a star, a veritable judicial star. We've been talking about reform of prosecutors, reform of the system, and the whole point about reforms is that you really can't really discuss reforming or the quality of reforms in the judicial and the system without really talking about what happens to judges, and that's been sort of the unknown in a lot of the discussions about justice reform over the past year or so. And to remedy that, we have for the next half hour or so, I want to have a conversation with Judge Gertner, now at the Harvard Law School, but formerly federal judge in Massachusetts, who has written a wonderful paper for Square One called Reimagining Judges. So what I wanted to do is talk to her a little bit about that in the time we have left. And it's a good coda to everything we've been discussing so far, because quite clearly, and as she points out, not much can be done about changing the system, making it more amenable to justice concerns, unless judges are signed on to the process. And that, in a nutshell, I think is what she talks about in her paper, but maybe we can get her to expand a little bit about why she thinks that, what led her to think that, and what her recommendations are. So, Judge Gertner, the floor is yours. We'll have a quick conversation after you speak. Give us about 10 or 15 minutes of the quick 20-cent summary of your paper, and then we can go on from there.
We're talking about the 20-cent summary or the elevator speech?
Elevator pitch is too small.
Yeah, too small. Okay. Well, this is a paper long in coming. So I was a criminal defense and civil rights lawyer before I became a judge. And I was, I was a judge when I was appointed when I was 48, and I had decades of experience as a trial lawyer in those areas. So the concept of a judge as, sort of ascending the bench and suddenly shedding all of the experience that they'd ever had before was preposterous to me. The question was always how to deal with that experience, how that bears appropriately on what you did as a judge. That was counter to this notion that judges, just the outcome is spit out when you apply the rules to the facts. There were so many ways in which what I cared about could be enacted in a courtroom. The simple things. How much time you gave to sentencing. I was under a mandatory guideline regime for for half of the time I was on the bench, but I still insisted on lengthy sentencing hearings because I was prepared to try to have an understanding of the human being, to see whether there was any wiggle room in the guidelines at all. I believed I was teaching sentencing at the same time I was on the bench, and I was trying to see whether or not these ostensibly immovable guidelines had room for interpretation. And in all of that, I thought that was entirely fair to do. I was taking away people's liberty, and it seemed to me that finding a way of mitigating harsh punishments was appropriate. Finding a way to interpret the guidelines was appropriate as well. And even when I had no choice at all, like in a mandatory minimum, I, like Judge Gleason, Judge Bennett across the country, Judge Gleason in the Eastern District of New York, felt very much that if you were imposing a mandatory minimum on someone, you should say how preposterous it was. And you should say how unfair it was. So let me give you, so I wanted to write about not how this was an aside, but that this was central to the mission. Having some sense of context, having some sense of where the law was going, having some sense that would then animate the way you would deal with cases, the kind of hearings you would hold, that would animate the way you'd interpret the law. And that's what I thought was terribly important. And let me sort of make it even more personal rather than abstract. Because I was teaching, I went to an international conference in Glasgow. I was on the bench for about a year. And I, for the first time, listened to other countries talk about American sentencing. And there was a panel with a description of incarceration rates in the Western world. And this was sort of pre-PowerPoint. And when they got to the United States, they had to keep on unraveling the piece of paper because we were so far outside of the mainstream of Western countries. It was like someone had added up a column of figures. And all of a sudden you said, oh my God, is this what we've been doing? And it encouraged me to look more deeply into what I and others were doing, to try to understand the context. And just to give you an example of how that applied, I had a case involving a felon in possession of a firearm. And I was stunned to find that the government wanted a very long sentence based on 3 prior convictions. The convictions were for driving after his license was suspended in the white suburbs of Boston. And it was clear that unless you examined those convictions and understood the context in which they occurred, that the sentence would be dramatically longer. And this context in which that occurred is an African-American guy who clearly was being picked up for driving after his license was suspended because he was Black. And I not only refused to impose the harsher sentence, but I wrote an opinion highlighting it. So I thought that my experiences and the context, the environment that I came from should inform what I did. Then I began to go to conferences like this, and I realized that judges are never at these conferences, looking at the consequences of mass incarceration, the consequences of sending people to prison in the middle of the country, and how terribly important it was to bring this context to bear on sentencing. I watched as judges across the country seemed stuck in what I came to believe called the habits of mass incarceration. The previous panel talked about this. 40 years of a retributive sentencing system meant that we became immunized to sentences that were outrageous. What before had been a 1 or 2 year sentence was now 10. And that sort of came trippingly off the tongue. We became immunized to the consequences of what we were doing. And that was no more clear, actually, with respect to progressive prosecutors who hit pushback from judges in their jurisdictions who would reject null process or reject dismissals when there had been decades of always believing whatever the prosecutor said. I saw that in compassionate release cases. When the pandemic hit, judges who were stuck in the world of mass incarceration feared decarceration, feared what would happen even when elderly prisoners were released. And it was clear that there was a narrative that was somehow inescapable unless we broke through. I didn't have that narrative because of where I started, but certainly other judges who came from prosecutorial backgrounds or had no experience with the criminal justice system were in that narrative. And it was clear to me then that when we, a lot of reforms are talking about, judicial discretion. It was clear to me that giving more judicial discretion was irrelevant until you dealt with the habits of mass incarceration. And this goes to, I think, a comment that Kim Fox just made. The habits of mass incarceration and the narrative that we are stuck in and have been stuck in for 40 years are part of the same picture. And until you change that narrative, until we change it, once there's an uptick in crime, even to the slightest degree, or some celebrated case, we will continue to default to this. I was concerned not just about the habits of mass incarceration, but the institutional supports for it. Judges are rarely trained in sentencing.
So how do we get out of that? I mean, we're now in a position which is unfortunately what part of the theme of this conference is, that after we seem to be inching towards a different approach, even if the judges were not on board, now we're heading back the other way, back towards a traditional approach to crime, to prosecution. And certainly the judges are not standing in the way of that. So Are you worried that we're going backwards again, and that any hope of change is ephemeral, or is there something else you think can? I mean, is there something that we're not seeing somewhere out there that maybe there is a possibility that things will change?
Well, I refuse. I can't survive if I don't believe there's a hope of change. I am a bedrock optimist because that's what sort of animates me to keep going here. I think there are a couple of things. One is we had begun to change the narrative. We have to work harder. In New York, for example, there were suddenly calls to undo bail reform, as if the bail reform was linked to the rise in crime. That's not true. It's empirically not true. The rise in crime during the pandemic is as attributable to the pandemic and the disruptions in communities as anything else. And every time I read something in the newspaper, I want to write an op-ed and say, that's simply not true. And you have to call it as it happened. We had the same thing in Massachusetts, where all of a sudden the courts were obviously shut down during the pandemic. And the chief of police said, well, the people on the street, the murders are because people aren't getting to court. And it simply wasn't true. The people who were doing the crime were not the people who had, should have been in court. So we have to counter that narrative everywhere we find it. Judges have to be trained in that.
So what are the concrete steps that we need to take? Obviously, we're talking about federal judges as well as state judges and local judges. I mean, are there different approaches for each type of person who's sitting on the bench?
Well, the training of judges has to include programs like this. Mm-hmm. Judicial training is all about rules and whether you're going to get appealed and whether you'll be reversed. It is not about the context of mass incarceration. It's not about the consequences of your sentences. So judicial training has to be this. And as I said, I wound up in this because I was teaching. And so I got invited to a whole host of things and I was stunned at what I was hearing. Judges don't hear this. And even if there's not a one-to-one correlation between conferences like this and what you do the next day in court, it animates the next bail argument. It animates what you do with the next sentencing. So that was one thing. And then I wanted to analogize in this paper what we are doing with police officers now. Movement to sort of keep, and you were talking about this with respect to prosecutors, keep book on prosecutors and police in the sense of keeping data about stop and frisk, keeping data about prosecutors who engaged in misconduct. There's no such book for judges. I cannot begin to describe to people how insular the job is. There's no such book. The only measure of whether I was a good judge is, how often I was reversed. In my court, I actually found that a badge of honor. But if we had transparency with respect to sentencing about racial issues, about correlation with racial issues, correlation with severity, and you didn't have to give it to the New York Times. You could give it to judges and let them look at it in the way we want police officers to be reflective. That would make a difference. I also wrote about a different kind of accountability. Stephen, you know that I'm working on a book about the men I sentenced whom I'm meeting. And it occurred to me that judges are accountable, again, only to appellate courts and case management statistics. What if judges, in the case of a wrongful conviction, the case of recidivism, what if there was something like a clinical review of what the hell happened and how all of the players contributed to what happened? A wrongful conviction on the one hand, or recidivism on the other. The judges are never accountable for outcomes in that way. And if we can make them accountable, I'm not talking about impeachment, I'm talking about bringing them to the table when there is a bad result. So if I release somebody and something happens and there's and he commits another crime and it's on the front pages of the newspaper will record a police error, will record possibly a prosecutor error, and then they're bound to be recording of, did the judge release them, too soon? we should have a different kind of accountability discussion, right? You know, and then I think we can broaden it.
Isn't the threat of impeachment effectively the only effective mandate you could have? Because otherwise, it's a cultural thing, and we're talking about a cultural change that could take generations.
The threat of impeachment is not going to, obviously, it's like in thermonuclear war to deal with a violation is not going to happen. It's just not. But we could talk about training. As I said, if there had been if there had been a wider discussion about the impact, for example, of federal sentencing in communities of color, impact on intergenerational crime issues, impact on families, impact on communities. If we had had that discussion, maybe in the 2001, 2, 3, or 4, maybe some judges would be changing. Yes, you're right, it's a cultural shift. How do you enhance that cultural shift? Presenting statistics, about bias would be one way. I'm not sure what the structure of accountability would be, if that's your question, because it can't be that because of judicial independence issues, that you tell a judge, well, you didn't take X into account, you're going to be impeached, or I'm going to reduce your salary. Or there'll be it can't be that way. It is a cultural shift. But it's a cultural shift. Judges have to be at this table.
Judges have had a hard enough time being told to abide by risk assessment. So
right.
It's hard enough to get them.
Although actually, I actually think that some judges have an easier time dealing with risk assessment, because then you don't have to judge. You don't have to judge. But it is, I can't tell you how insular the job is. In this piece that I wrote in the book that I'm writing now, I contrasted the difference between when I was a criminal defense lawyer and when I was a judge. It's like criminal defense lawyer, I was in every inch of Boston. When I became a judge, suddenly I was taking my car to the Boston downtown courthouse, missing all the neighborhoods, and we were encouraging that kind of distance. I mean, I think so. It's training. It's also obviously whom we select as judges. Because I mean, I came to the table with a context most judges don't. I talk about in this paper sort of a stunning moment in the trial of a Black man for drugs. I would have him sit in my lobby when I was selecting jurors. So he was within shouting distance of the juror. They were around the same table. And a white woman, an older woman, when we said, do you have any problem serving as a juror on this case? She said, I'm afraid to come into Boston. She lived in one of the suburbs. I understood that was code. Mm-hmm. That code was, I'm afraid of this guy. And, and so it mattered that who you put on the bench. It matters how you treat people in your courtroom. I mean, there are things we can do. How to enforce it? You asked a question which I've been trying to avoid.
Well, you touched on something, I think, a moment ago that's really essential, is selecting the right judges. So how do you do? I mean, we elect some judges, we appoint others. I mean, is there a consistent way that we can make sure we get the judges we deserve? Is that a governmental type recommendation that can be made, or one to the Bar Association or to state legislatures? I mean, are there guidelines that people should look for when they try to measure what a judge is, instead of just as a kind of reward for a good service as being right. As a prosecutor? Well,
I think that federally,
political payoff.
Biden has and Elizabeth Warren and Senator Markey have both, Senator Warren and Senator Markey have both tried to change that discussion. And I know that's going on around the country with federal selections, so that the lens is not just prosecutor, big firm lawyer, it is public defender, it is public interest lawyer. So that certainly is one thing. And I suppose that the strategy with respect to elected judges is the same strategy as with respect to elected prosecutors. How did they get to the table? And that's what we have to talk about. I might add, it's the same strategy that we see with the proposed nomination of Judge Ketanji Brown Jackson.
Yes.
There's a wonderful comment that Justice O'Connor made when Thurgood Marshall was retiring, when Justice Marshall was retiring. And she said he changed the conversation in the room, that his presence and the things that he had seen changed the conversation in the room. And that's another reason for diversity, not just racial and ethnic, but diversity of background, to change the conversation in the room.
So in the time we have left, I want to open it up to questions as well. If you have a question, please put it in the Q&A window or raise your hand so I can see you. Please don't hesitate. We have about 5 or 10 minutes left before we wrap it up. But Judge Gertner, you wrote this paper just about a year ago. What's been the reaction since? You think you've changed anyone's mind?
I haven't the foggiest idea. I mean,
what have people said? What have your colleagues said?
The only people, I haven't heard from my colleagues.
Oh, that's interesting.
Yeah, I haven't heard from my colleagues. And it was actually released a few months ago, so that there's still time, but I really haven't. It collides with the Justice Roberts, Justice Thomas view that judges shed all entangling experiences the minute they step up to the plate. And that's certainly the easier way to be. So no, I haven't heard any pushback. Let me add just one other thing to a previous question. The media, as your previous panel noted, plays a role in this. I only got criticized for a sentence if it was below what the prosecutor wanted. I never got criticized, if I did what the prosecutor wanted or went above. I never went above, but so the media enforces the pressures on a judge. This is something a federal judge can do, a state judge can't do. I also wrote opinions. And as I said before, I wrote opinions. The first page and a half was a press release. It was, I'm doing this and here's why. And it was really sort of speaking to the media, because I knew, it's like, I know you want to characterize this as some touchy-feely liberal thing, but let me tell you what's going on here. And what I found was the coverage of what I did was different. Maybe the answer to that too is, judges should have press offices so that you can't caricature what they do. That's part of changing the narrative. That's part of what we've talked about before.
Or perhaps be out there in the community more like you are, being much more personal than sitting up on a high bench.
Right. The conversations I've had with the men I've sentenced, not all of them, just about 10, have been stunning, about what they knew and what they saw. And, I don't recommend other judges do that while you're on the bench. It's a little, it's not easy to hear.
So here's a question, asking what your take is on the counterpoint around judicial discretion. And when system actors have more discretion, it tends to be generative of racial disparities. So he's asking, is there an argument for standardized sentencing that is just far less punitive rather than increasing judicial discretion?
Well, when we talk about police who are acting in a racist fashion, the answer to that is not mandatory arrest or mandatory not arrest. We say, look at your patterns after the fact and then see what animated them. So with respect to judges, I'd like that model. I understand that discretion could breed bias and had led to bias. So there should be after the fact review that then goes either to the judges or goes more generally, but after the fact review. What did you do in the case of this white man? And then you did something different with respect to this Black man. Guidance is different than guidelines. And the problem is that any abstraction about crime never matches the individual case. The classic example, just because is what I know the best, there's a guideline for armed robbery. Man, that sounds terrible. And typically, guideline writers envision the worst version of the crime. And there may be a range of versions, right? The guy who the drug addict who walks into a bank with his hand in his pocket and walks out covered with dye and waits for the police to be called is not the same bank robber as the Italian job. The problem with guidelines is that in an effort to constrain judicial discretion, they over-constrain judicial discretion. So you can't make those distinctions. So yes, there can be guidance, presumptions, but there should be after the fact review so that a judge can exercise judgment.
Here's a final question that I was just about to ask you, but it's posed a little bit much better here by the questioner who asks, how does the public who's asked to vote for local judges begin to determine who to vote for if we have no knowledge of his or her record? We don't go to follow court proceedings. And I guess, the follow-up on that question is how political does a judge need to be? Do you need to go and make your case before legislators, as well as before chambers of commerce?
That's an issue with elected judges about making their case. The problem is that elected judges wind up being political to the degree that they can, and that's a problem. I thought that also in the questioner's question was the problem about transparency.
Mm-hmm.
Sentencing is, in one sense, the least transparent thing that a judge does. Yes, it's done in open court, but unless you're sitting there, you rarely can sort of take book on the judge. In the federal courts, in one court I was studying, sentencing memoranda and the statement of reasons are confidential. That means the only people who know what's going on are the lawyers in that case. But if you wanted to come up with a pattern, you couldn't possibly see it. And state court judges who don't write opinions, and have even less paperwork are even less transparent. That has to change. If you want data to constrain discretion, get the data. And that could help both for elected judges and appointed judges.
So that's a legislative guideline, transparency or accountability. That's something that certainly can be legislative mandated.
Yes, it's really quite stunning. If you wanted to figure out what the patterns of behavior are for judges, not for the purpose of trashing anyone, but for the purpose of, in part for a judge's own view, as well as to figure out whom to elect, you need some record. Mm-hmm. A judge, when he dismisses a case or she dismisses a case, has to write an opinion. And that opinion is appealed. But when you sentence, you don't have to write an opinion. That's in the federal system. You write on the statement of reasons, which could not be more perfunctory, and even that's sealed.
Right.
So it's if you want to change the narrative, if you want to change behavior, transparency is the way to do it. But and you have to be careful because given the narratives of mass incarceration, there's always a chance that the narrative will only focus on the judges that the press perceives to be more lenient. In other words, the prosecutor will say, so-and-so sentencing was more lenient, rather than focusing on the judge who threw everybody in jail no matter what.
Right. These arguments are driven largely by the prosecutors of the district attorneys associations.
Right. And there has to be a counter to it.
Yeah.
There has to be for every individual who went awry after having been released, there may be 10 in your court who did just fine. And if you don't have that data, there's no balance to the coverage.
Okay, I think we'll have to leave it there. We can go on for another half hour, but I want to give people a taste of your thinking, but I highly recommend that everybody go back and read the paper in full. It will repay closer thought, and I hope will give people ideas of how to cover this issue, which is still largely unexplored in the media, a bit better. But Judge Gertner, thank you very much for your time. This was great. And for everybody else, this is our last final session of the day, and we're going to resume again tomorrow at 9 o'clock in the morning with another full, and I hope you'll think stimulating program. The agenda is available on the conference website. You should all have copies of it, as well as the bios of the various speakers and fellows. So thanks for being with us for the entire day, and thank you, Judge Gertner, and we'll see you all tomorrow. Thank you. Have a good evening.
Thank you.